Supreme Court's verdict on Aligarh Muslim University is concerned. What we're given to understand is that the hearing on AMU's minority status is underway as we speak. In fact, verdict by 7-judge Supreme Court bench. CJI says judgment is a 4-3 majority. So significant development as far as this is concerned, given the fact that CJI has also stated that the decision in Aziz Basha's overruled and the question on deciding the minority status of AMU must be done on the basis of the tests laid down in the present case. This is, of course, as we speak, more developments that are coming through in terms of the legal remarks. Let's listen in.
Two key aspects of the issue. One, what are the issues identified in Anjuman which are intended for the larger bench to address, and two, whether the manner of making such a reference was legally sound. On the first part, we have said it is crucial to determine whether the bench in Anjuman intended to restrict the reference in such a way that the 7-judge bench would only analyze the criteria necessary for an institution to qualify as a minority institution under Article 30 of the Constitution. For the sake of clarity and despite the risk of repetition, we find it essential to put forth the relevant extract. Then again, we have reproduced the reference order and then explained a plain reading of these observations revealed that the 2-judge bench in Anjuman doubted the correctness of the decision Aziz Basha and the principles enunciated therein. The bench, while questioning the holding of Aziz Basha, also borrowed strength from the views expressed by some jurists. In Aziz Basha, the issue pertained to the constitutional validity of AMU 1951 and 1965 Amendment Act. While questioning the correctness of the decision Aziz Basha, it is evident that the reference in Anjuman also insinuated that potential errors may have occurred in the analysis of the constitutionality of those enactments. The reference seeking to reopen the issues settled in Aziz Basha thus necessarily mean not only to re-examine the correctness of that decision, but also an attempt to revisit the constitutionality of the AMU 1951 and 1965 Amendment Acts. Importantly, the key term used in the reference order in Anjuman is "and," which is clearly used to state that both Aziz Basha's case may also be considered, and second, the ingredients of a minority institution should be examined definitively. Such an analysis would also have to consider the question posed in TMA Pi under 3 sub A regarding the criteria required for an institution to qualify as a minority institution under Article 30 of the Constitution, and consequently as to whether AMU fulfills such criteria or not. We therefore find it difficult to align ourselves with the opinion expressed by the majority led by Honorable Chief Justice, according to which the reference before us was limited to determining only the criteria an educational institution must meet under Article 30 of the Constitution. However, given the Honorable Chief Justice's decision to further refer the matter pertaining to AMU to a regular bench, we have confined our views to discerning the relevant indicia under Article 30 so as to avoid binding or influencing the regular bench that will ultimately decide the factual issue. Then on the question of
these are the live proceedings that we're given to understand that is, of course, unfolding in the top court. But what CJI Chandrachud has said, while, of course, talking about this, is that, quoting the same, not necessary that minority can only be implemented if the persons of the minority administer the institution. So the CJI said that it's not necessary that the purpose of minority can only be implemented if the people of the minority administer the institution. We'll continue to track all the key takeaways as far as this is concerned and more. But for the moment, slipping into a quick break here on The Big Story.